I welcome you all to our virtual event dedicated to thinking through the international legal challenges raised by Russia's invasion of Ukraine. This event is organized by the Edinburgh Center for International and Global Law and the Global Justice Academy. And what we intend to do today is offer you short policy-focused presentations over the next hour and a half over a range of perspectives across the field of international law to think about the role of international law in response to the war. In particular, we will think through issues of civilian protection, human rights, criminal accountability, geopolitical security, the rule of law challenges for post-conflict Ukraine, and the shifting landscapes of international financial sanctions, as well as the multi-stakeholder approach to regional and global governance. So a series of 8 short presentations will be followed by a Q&A session. Now, before we start, a few housekeeping rules to be mindful of. I will ask the presenters, including myself, to kindly mute their microphone while others are presenting, and please make sure to speak for a maximum of 8 minutes to allow enough time for the Q&A. I will ask the audience to please address their questions and comments in the chat box in real time as we progress through the presentations to allow us a smooth transition to the Q&A session as the presentations draw to a close. Lastly, I wish to thank the visible and less visible forces who helped with the organization of the event, namely Michel Mulvis, Elizabeth Barlow, who is our Research Communications and Impact Manager, and Ian McGee, our Research Communications and Events Officer. And for our first presentation, I will now hand the microphone to Professor Stephen Neff, who will present us his thoughts on the law of armed conflict and the protection of civilians.
Yes, thank you. I will just have a few general remarks to make here. It's very difficult to see how these general rules apply to the particular situation in Ukraine, because the fog of war is settled very thickly over the events there, and it's very difficult to have an idea of what the facts actually are. Now, to some extent, we have some hard and fast objective evidence in the area of protection of cultural property, which I'll mention presently. But okay, so just a few general things and a few points about protection of civilians that are perhaps not so well known. First of all, the law is rather importantly different when it comes to protecting civilian persons as opposed to civilian objects. Civilian persons being more effectively protected. And first of all, the basic rule is very simple. It's an absolute one. If there is ever any absolute rule in the whole of the laws of war, it is an absolute rule against the targeting of civilian populations as such. There is absolutely no exception to that. And I might add more generally, there is no derogation from humanitarian law at all, in sharp contrast to, say, human rights law. There is also an absolute bar on reprisals against civilian populations. Now, there have been reports that there have been apparently reprisals against civilians being taken, but I don't know how credible those are. And finally, I would say that point out that there is an absolute prohibition on using starvation as a method of war, but as far as I know, that hasn't entered into the reports of the conflict as yet. All right, now to civilian objects, let us shift over to them. And on civilian persons, incidentally, the good news is that there's an absolute ban on targeting civilians as such. But a very large sort of caveat to that is that the law does allow for collateral damage to civilians, provided that it is proportionate to the military advantage being gained. Now, over to civilian objects. The Protocol 1 of 1977 contains an actual definition of the expression military object. And so military objects are targetable, non-military objects are not. You ask, what about dual use objects? And the provision there is that dual use objects are targetable. That is, so long as the definition of military objective is met, then the object is targetable, even if it has a civilian use. So the law is less far-reaching in favor of civilians when it comes to objects as opposed to persons. Now, there are three exceptions to this rule of targetability of dual-use objects. The three exceptions are, number one, objects indispensable to civilian life. Number two is objects containing dangerous forces, that is, dams, nuclear power installations, and things of that character. And number three is cultural property. Now, all of those have exceptions. Notice that those themselves are exceptions to the general rule that dual-use objects are targetable. Those exceptions have some exceptions, and those exceptions to the exceptions have some exceptions. And in one case, there are even exceptions to the exceptions to the exception to the exception. But I won't go into those just now. My 8 minutes would be exhausted. But the law is very elaborate and very fiddly on these subjects. And as I say, we don't have concrete information here on the extent to which these have been violated so far. The one area is the third one, cultural property, in which we do have some evidence from UNESCO about what has been happening in Ukraine. And they have UNESCO has reported damage to a large number of sites. 29 religious sites so far have suffered war-related damage, we are told. 16 historic buildings, 4 museums, and 4 monuments. And I don't know of the exact extent of this damage or the details of them. Ukraine is happily the home of 7 UNESCO World Heritage Sites, but so far as indications are presently available, those have not been damaged as yet. And so I think that that's a necessarily very rapid view of protection of civilians, and so I will be available for questions when question time comes. Thank you.
Thank you very much, Stephen. Without further transition, I will hand the floor now to Captain Ian Park from the Royal Navy and the UK Ministry of Defence, who will present us a view on the UK Integrated Review of Security, Defence, Development and Foreign Policy and the Crisis in Ukraine.
Thank you very much indeed. I need to begin with a small apology. They've decided to dig up the road outside my flat in London. So I'm hopeful that the microphone doesn't pick up too much of that noise, but if there is a noise in the background, that's it. On the 16th of March of last year, the UK government published a document called Global Britain in a Competitive Age, which is the integrated review of security, defence, development and foreign policy. And this was a major exposition of the UK's position on these issues. And it was significant insofar as these reviews typically only take place every 5 years or so. So for the next few minutes, what I'd like to do is make reference to that document and see the extent to which it anticipated what we're seeing now in terms of the war in Ukraine, and also consider some of the current and future challenges that we face at this time. So to begin with, I think it's fair to say that the integrated review did identify the issues that we are seeing now in respect of the Russian invasion in Ukraine to an extent, insofar as the integrated review made specific mention on a number of occasions that Russia was the most acute direct threat to the UK. And as a consequence of that, it restated the UK's belief in collective security through NATO and emphasized the fact that the UK would participate and take a leading role in NATO with a view to deterring a range of threats that would emanate from Russia. More specifically, the integrated review placed some emphasis on countering disinformation and also media development. And it specifically stressed the importance of understanding and exposing this disinformation threat. And I think that is an area in which we have seen significant Russian activity in an appalling way, in the sense of the massacres in Baku and elsewhere. And the integrated review made specific mention of ensuring that we as the UK and NATO and internationally are in a position to counter these threats. The integrated review also made specific mention of the role of the Organization for Security and Cooperation in Europe, and made specific mention of that organization's special monitoring mission in Ukraine, and also made mention of the Council of Europe's efforts to ascribe attribution of Russian hostile and destabilizing activity. Now, clearly there is a legal dimension to this, of course, made more difficult by Russia withdrawing, being expelled from the Council of Europe. And I'll mention something more about the human rights dimensions of the integrated review in a moment. In addition, the integrated review set out the fact that in being the most acute threat in the region, the UK would have to involve itself early in terms of engagement and assistance in respect of any nations that were threatened by Russia. And I think there is evidence to suggest that the UK was one of the early countries that provided assistance in a number of forms to Ukraine. And we could see this in respect of the actions in terms of anti-tank weapons and defensive capabilities. Turning to some of the current challenges that were identified in the integrated review, it's fair to say that the war in the Ukraine poses a significant threat to the rules-based international order. And it's absolutely incumbent upon states to defend this in a number of different ways. We have seen significant hostile cyber activity on the part of Russia, and it's important, therefore, as a matter of law, to be able to attribute that activity to Russia and to act collectively as states in this. As I've mentioned, in the information age, it's also significant to counter the Russian narrative and ensure that this is done in a range of fora, including the International Court of Justice and through the activities of the International Criminal Court. It's also significant that states can act in the hybrid arena and use a combination of soft and hard power methods to counter state threats emanating from Russia, but also more broadly from states such as Iran and North Korea. The integrated review also made specific mention of the threat to energy security. And it's telling that today the UK government set out its energy strategy, because clearly in the longer term, it's of states' interests to ensure that they have energy security and therefore aren't reliant to the same extent as they are presently on Russian oil and gas specifically. The other area of the integrated review that is significant is the UK's promises to protect human rights and an unequivocal desire to do so. This is significant because in the integrated review, the UK government specifically said in the following terms: our first goal is to support open societies and defend human rights as a force for good in the world. And I think it's incredibly important that, having stated that publicly in such an important document, that the UK follows through on that promise and ensures that human rights are protected. Turning to my final points, I would like to conclude by offering some thoughts on the considerable challenges that remain. So I think, firstly, the international community and NATO ought to remain united in its opposition to Russian action. This sounds obvious, but I think it's incredibly important that states continue to act collectively in support of Ukraine. Secondly, it's important to maintain pressure on Russia through legal fora, as I've mentioned, the International Court of Justice and the International Criminal Court, and also through the United Nations, and make significant efforts to try and encourage states that haven't perhaps been as supportive of the UN's efforts to be more so in future, particularly in terms of the atrocities that we're seeing. Thirdly, it's imperative that states continue to maintain support to Ukraine militarily, in a humanitarian sense, and financially, and also maintain interest in the crisis and the war in Ukraine to ensure that we are there to support Ukraine in the long term. We must not lose sight of the fact that in Chechnya, that was a decade-long conflict, and we need to be alive to issues such as that. And then finally, I would suggest that we have to be in a position to support any solution that is negotiated and any peace deal ultimately, and be able to assist in those significant matters. And allied to that is the issue of accountability, and therefore the importance of the collection of contemporaneous evidence, particularly in light of what we have seen in the last few days and the tragic circumstances that are emerging. I will leave it there. I think my 8 minutes is up, but thank you very much indeed.
Thank you, Ian. Unfortunately, Ian won't be able to attend the Q&A because of his professional obligations. So I just want the audience to be mindful of that. It's my turn to talk about the protection of the environment under the laws of war, and I will follow a temporal synthetic approach to the laws of war by observing the laws of war before a conflict emerges, during the conflict, and after the conflict. So before the war, I think it's important to stress that the safest way to protect the environment is to respect the UN Charter and to conduct a peaceful resolution of conflicts. So the jus contra bellum is the safest guarantee to the protection of the environment. However, if prior to the launch of attack, the International Red Cross 2020 guidelines suggest the conduct of an environmental impact assessment according to the precautionary principle. And according to this environmental impact assessment guideline of the International Red Cross, opposing parties must inform of the existence and location of conservation efforts in areas of particular ecological significance or fragility. In the case of the Ukraine, this would comprise World UNESCO sites such as the virgin beech forests in Ukraine's Carpathians. But Stephen touched upon the cultural heritage, so I won't delve further into this topic. I just want to conclude that before the war is even conducted, it's the precautionary principle that applies. Now, During the war, we have, of course, the jus in bello rules of engagement that apply, and the protection of the environment is a civilian object unless it becomes a military objective, providing, for instance, camouflage to the enemy. So in this context, belligerents must take into account foreseeable effects of the operations, military operations on the environment. They must take into account the cascading knock-on effects of environmental damage on the civilian population that may cause significant environmental damage. So what about the Russian military attack on the nuclear facility in Kharkiv, for instance? Well, in this instance, it is clearly a disproportionate attack that poses risks of indiscriminate harm to the civilian population through environmental degradation. So environmental degradation or the protection of the environment in the laws of armed conflict are linked to, as Stephen mentioned, the civilian object. So I want to also mention that on the Ukrainian side of the conflict, the forces flooded arable land to prevent tanks from advancing through the fields. So here, during the conduct of the war, a principle of proportionality applies to the conduct of belligerent operations. After the war, there's a regime of jus post bellum, a regime of relief and assistance to remove toxic hazardous ordnance. And here we might mention the important role of the Unep and Undp post-conflict environmental assessments. I want to mention the Protocol 5 of the Conventional Weapons Convention on Explosive Remnants of War, which requires warring parties, including Russia and Ukraine, which are parties to the Protocol 5, to survey, assess, and clear those explosive remnants of war. And Ukraine has already requested technical assistance for clearance under the protocol in 2008 and 2009, and will probably request further assistance after the war. So in conclusion, after the war, the principle of remediation applies. Outside of these laws of war, I want to mention that post-war zones have become their own cultural and area studies, so offering new ways of understanding the parallel relationship between war violence and post-war revival. And interesting ethnographic studies have shown that over time, wastelands can become rice fields, old craters can become shelter orchards. In post-World War II Warsaw, 20 million cubic meters of rubble were transformed by a ruderal society. So contaminated sites are not experienced by those that inhabit them as necessarily wastelands apart from everyday life. So in conclusion, I wanted to stress the importance of conducting an environmental impact assessment before the belligerents even conduct military operations. The respect of the proportionality principle while belligerents are engaged in warfare, and the principle of remediation once war comes to the close, and relief and assistance to remove toxic hazardous ordinances it compels belligerents to participate in technical assistance. So I'll stop it here, and I want to invite Dr. Casey McCall-Smith to present her take on the framing of the conflict in human rights.
Okay, thank you, Michael. I think what I'm going to just briefly talk about is the tension between human rights law and international humanitarian law. So there's been a separatist kind of position that human rights law and humanitarian law are fundamentally different and irreconcilable, because and it's not widely invoked, this separatist thought anymore, because so much work has been done to talk about the mutual applicability of human rights, even in times of conflict. So while clearly the law of armed conflict is only applicable during conflict, human rights are recognized to apply even when there is war. Though human rights might be tempered and restricted in line with the situation. So I basically want to kind of speak to two issues today, contrary that note the contrary position that human rights law and international humanitarian law, or the law of armed conflict, are not reconcilable. In fact, I want to focus on the shared values of international humanitarian law and human rights law that underpin some of the most fundamental norms that underscore human dignity in both times of war and peace. And I don't do this lightly, because in armed conflict, there's no way to address all of the extensive and expansive promises that are made by human rights law. But I want to focus on kind of the negative dimensions of human rights protections rather than those positive dimensions that in international human rights law and its monitoring mechanisms we tend to focus on. So both Russia and the Ukraine are party to a multitude of international human rights treaties, and that's in addition to the European Convention on Human Rights. So these obligations remain in place throughout armed conflict, though, as Steve mentioned earlier, they have the right to derogate these treaty obligations, and that's very common in conflict. Derogation, however, to some of these the two human rights that I want to talk about are not permissible. I'm going to focus on the ICCPR, so the International Covenant on Civil and Political Rights, because it is kind of the primary go-to whenever different conflicts break out, because those are the most immediate and obvious and generally applicable civil and political rights. And both the Ukraine and Russia are party to the ICCPR, but I'll just go ahead and mention that the two rights that I'm going to talk about are also present in the other treaties that both states are party to, which include the Convention on the Elimination of Racial Discrimination, the Convention on the Elimination of Discrimination Against Women, the UN Convention on the Rights of the Child, and the Convention on the Rights of Persons with Disabilities. And I mentioned those, particularly those last three, CEDAW, the UNCRC, and the CRPD, because reports have specifically indicated that these particular groups have been suffering the brunt of the attacks against civilians. So under ICCPR Article 4, states can derogate from their human rights obligations, but they can never derogate from a few of those. And what I'm really focused on here and concerned about is the right to life and the prohibition against torture. So those are non-derogable. I think it's important to note that the Ukraine has filed derogations to the ICCPR in light of the fact that it has imposed martial law, which will obviously restrict many of the civil and political rights of the people. But that derogation does not apply to the prohibition against torture or the right to life, as I already said. The right to life is protected not only in the ICCPR, but under the CRPD at Article 10, the UNCRC at Article 6, and also throughout CEDAW. So Russia, as I said, is party to those same conventions, but it has not filed a derogation at this point. Now, this tends to concern the applicability of human rights obligations outside the territory, but as we know, much of the fighting is taking place in areas that have been somewhat under the control, if not fully, but at least in practice, probably, by Russia. And so under the effective control arguments, Russia has an obligation to maintain its human rights obligations. But I think what's important here is also to think about where this right to life and the prohibition against torture overlap with IHL. Geneva Convention 4 is on the protection of civilian persons in times of war is really what I'm looking to. So whether we're talking about Common Article 3, its application, which looks at when conflicts aren't viewed as international conflicts. And I think here I'm only raising this because this could cover infighting amongst different Ukrainian factions. So that dimension could be seen as non-international, but also Articles 13 in combination with Article 32 of the Fourth Geneva Convention, where civilians are to be protected from murder, torture, and different types of brutality and discrimination as well on the basis of any protected characteristics such as race, nationality, religion, or political opinion. And so why I raise these particular articles, because they very much reflect what we understand in human rights law to be these protections. And as of yesterday, 2 days ago, the 5th of April, the UN High Commissioner on Human Rights had recorded that there were 3,675 confirmed civilian casualties in the country. There were also a further several thousand that had been injured. So of these civilians that had been killed, there were a large percentage of women and children, including pregnant women and women who had just recently given birth. So many of the civilian casualties recorded were caused by the use of explosive weapons with a wide impact area, including shelling from heavy artillery and multiple launch rocket systems. So these are missile, ground missile and air strikes that were used indiscriminately. So this is one area where there has been no precaution in terms of the recognition of the right to life and the prohibition against indiscriminate killing, and these align with the UN human rights standards. There have also been attacks against significant civilian objects, which is contrary to Article 14 of the Geneva Convention, because hospital and safety zones are meant to be protected. And there have been frequent confirmed reports that Russian military has attacked hospitals and places where civilians were sheltering. So just to conclude, I think we have to wait for the evidence to play out, but I think it's important that we do evidence and spend a lot of time ensuring that evidence is maintained about these attacks, because not only are the potential of war crimes, which I know colleagues are going to speak to, relevant here, but also there will be necessary human rights claims and the human rights monitoring systems and individual claims that can be made in the aftermath of this situation. And we need to make sure that we pay as much attention to supporting individuals in the Ukraine in the aftermath of this as possible. Thank you.
Thank you, Casey, for keeping the time and giving us an overview of regime interaction between human rights approach and other regimes. I hand the floor now to Dr. Filippo Fontanelli, who is going to present his thoughts on lawsuits, interim measures and absences, legal proceedings before the International Court of Justice and European Courts of Human Rights.
Thank you very much, Michael. Sorry you had to read out the title. It looks better when it's written down. So yes, the topic of this short presentation is, in a word, if you want, lawfare. We hear stories about warfare, which are unfortunate, and we can now zoom in on the lawfare that is happening around it. And by that, I mean an organized reaction carried out in different ways and with the support of many states. So there's actions in international organizations, in a range of them, from the European Bank of Reconstruction and Development, Universal Postal Union, ICAO on civil aviation, Maritime Organization. Today, there's a vote at the General Assembly on Russia's status at the Human Rights Council. And then, within that context of lawful and legalistic reaction, there is litigation. I will offer a brief account of two litigation attempts that are launched by Ukraine, one before the International Court of Justice, the other before the European Court of Human Rights. Now, we need to make a premise. International litigation depends on consent. You cannot force a state to defend itself in court unless it has agreed to that method of dispute resolution for that matter. In other words, you can only litigate matters that both parties have agreed to litigate. So that's the reason why Ukraine cannot litigate the central matter of the issue, which is the invasion and the violation of the prohibition of an armed attack. Now, this fundamental limitation informs the attempts that are being pursued instead. And now, judged against this benchmark, you might believe they are imperfect and unsatisfactory because they do not strike at the core of the ongoing conflict. But they do capitalize on whatever little consent Russia has left lying around to litigate matters of international law before third-party adjudicators that can issue binding decisions. So, International Court of Justice. On 27 February, Ukraine lodged an application before the ICJ against Russia. On the following day, Ukraine added a request for provisional measures. So we have two requests, the main application and the urgent one. Let's speak about them in turn. The main application is one about the Genocide Convention. I don't say about compliance with the Genocide Convention because it is not clear whether the allegation is truly one about a breach, as it would normally be the case. Now, given the news of these days, you'd be justified in assuming Ukraine's application referring to the commission of genocidal acts by Russian forces, but that's not at all the case. The application of Ukraine refers instead to genocide by Ukraine. Of course, the purpose of the application is to debunk that hypothesis. But this is not a case about ascertaining the commission of a breach, the commission of genocide, but about refuting the allegation of a breach. Russia several times publicly declared that its armed intervention seeks to stop an ongoing genocide committed by Ukraine in the regions of Luhansk and Donetsk. Ukraine asked the court, therefore, to declare that no such thing occurred and that in any case, the Genocide Convention does not provide for the right to respond to genocide through armed activities. This is the best that can be done. For the armed attack would be outside the court's jurisdiction. Now, the application of provisional measures asks the court to take urgent measures and order the cessation of the attacks. This is a bold request, given that the main application referred mostly to a matter of interpreting the convention. The court held oral hearings and Russia did not show up, and then issued a decision 16th of March. It accepted through a rapid check that a dispute exists relating to how you interpret the Genocide Convention, and even accepted the Russian falsehoods as if they were genuine, observing that even if Russia really wanted to react to a genocide, then armed attack was not an available option. Now, this is a generous decision for Ukraine, which goes as far as observing that no genocide seems to have occurred. Now, what's the purpose of this legal strategy on the part of Ukraine? Of course, we know too well that Russia did not comply with these provisional measures. The attack has continued since the 16th of March. However, the application and the order, the main application which is ongoing and the order that has been issued had some effects. And let's talk about two. First, it completely and authoritatively debunked one of the recurring reasons that the Russian government had advanced for the attack. Now, there's no longer any credible space to speculate on whether Russia's allegations could possibly be warranted and explain the military operations. The ICJ at least made that much clear, even if it could not complete the determination and come to the foregone conclusion that the attack is altogether wrongful. Now, this determination has had a ripple effect on Russia's approach in public. The smoke screen of pretended explanation is now run very, very thin, and some of the talking points are just no longer presentable. The second effect is that the proceedings can represent a useful chronicle of the events on the ground and an impartial repository and forum to record these developments, the legal arguments, and the succession of the acts that Ukraine condemns. On the 28th of February, Ukraine also lodged an interstate application against Russia under the European Convention of Human Rights before the European Court of Human Rights, and again added upon it a request for urgent interim measures. That request was granted on the following day by the European Court of Human Rights. No hearings, no reasoned opinion, just a short one. In this application, Ukraine asserted that Russia is breaching various fundamental rights of Ukrainians, in particular the rights to life, prohibition of torture and degrading treatment, and the right to private and family life. And I'm glad Casey touched upon the application of human rights during armed conflict. The court agreed that based on the accounts, there is a real and continuing risk of serious violations of the convention rights of the civilian population, and therefore already immediately ordered Russia to refrain from military attacks against civilians and civilian objects. Also in this case, you would say the court has been generous to Ukraine. It accepted, as it had to do, on a prima facie, on a preliminary way, that Russia appeared plausibly to exercise control even outside its territory, because the alleged violations have occurred in Ukraine, not in Russia. And so it is a question whether Russia was bound by the convention there and then. 1 year ago, the court explained that an attacking state does not have to guarantee the application of the convention in the initial stage of an armed aggression, but then must do so once it has established control over the occupied areas. Here too, we must accept that Russia has not complied with the preliminary measures. With the interim measures. Lies on genocide, and before the European Court of Human Rights about the sufferings of the civilians, neither claim goes at the heart of the problem, that is the commission of an unprovoked armed attack. However, both applications form part of a legitimate attempt to encircle Russia through lawful actions and reactions, much in the same way you have economic sanctions and boycotts and actions at the international organization. I'll stop here, and I thank you very much.
Thank you, Filippo. Moving on with lawsuits and lawfare, our next presenter is Dr. Michel Mulvis, who will talk about innovations in international criminal justice, building on lessons from Syria.
Thanks very much, Michael, and thanks very much, everyone, for attending today. So basically, in some ways, I feel like watching the television right now is a little bit, unfortunately, of deja vu, because so much of what we're seeing now on our screens, the sort of bombed out buildings, the types of weapons being used, the types of reasoning even being supplied by Russia, we've seen in Syria. But what is different about, I think anyway, what's happening today in Ukraine is the explosive level of international criminal justice activity that is actually very much at the heart of the way this conflict is being framed. So although I'm going to show you how Syria, in many ways, I think, enabled the international criminal justice response that we've seen today in Ukraine, it was not the case in Syria earlier on. So I think we have a really big difference between how the conflict unfolded in Syria compared to how it's unfolding in Ukraine in terms of international criminal justice. And I think we wouldn't have anywhere near the level of activity or framing that we see today if it had not been for Syria. So what I'm saying most simply is that to understand the possibilities and limitations of international criminal justice in Ukraine, the only way to do that is to understand the lessons we've learned from Syria in particular. We could also look at other theatres, but especially given that Russia was so heavily involved in Syria as well, I think it's a wonderful way to make that connection. So I'm going to ask two questions basically, which is, where was the field of international criminal justice before this recent conflict? And that basically, I think, can be told through how the field evolved over the last decade in response or non-response to the conflict in Syria. And then the second question I'm going to sort of look at is the extent to which then this moment that is unfolding before our eyes every second in Ukraine marks a potential shift in how international criminal justice can respond post-conflict, but also obviously, as we're very much seeing, in real-time conflict scenarios. And I'm sort of going to argue then that really this is a very significant moment for the field. I think that many people right now in the field are extremely excited and anxious and active, and potentially this could be a moment of radical reconsolidation and reinvigoration of the field. But I also think it comes at great cost, because there is so much expectation and weight being placed on the possibility of forms of redress, of accountability. I think perhaps too much weight. And I don't think that much of that will actually come to bear fruit. Perhaps obviously in terms of simple narrative framing, perhaps, or moral condemnation, international criminal law is vital if we see that as some type of end result. But if we're talking about actual big trials, I don't think that anything like that is guaranteed. So potentially this could be yet another story of the failure of international criminal justice. So firstly, I just wanted to talk a little bit about some of the key lessons that we've learned from the failures of international criminal justice in Syria. Syria was a civil war. So in that sense, it is quite different really to the scenario we have here of alleged aggression. But I mean, interestingly as well, it was a civil war that became a regional war, and it was a civil war that involved a number of regional actors and was extremely significant in a geopolitical context. And that is very similar to the Ukrainian context. And remember as well that in some ways, Russia is also trying to frame this as a civil war, and that Russia has been involved in both conflicts. Russia, being a close ally of Syria, had from the very beginning sort of assured that Syria was protected from the full arsenal of international legal responses that could be brought against it, most significantly through its P5 membership on the UN Security Council and its ability, along with China, to veto UN Security Council referral to the ICC or any other possible international criminal justice response, for example, as setting up a specialized tribunal. And this is very similar then to really what we're seeing now because of Russia's prominence in the P5 in the Security Council as a P5 member. The sort of standard avenues that we would perhaps try to operationalize through the sort of the very high point of international criminal law is going to be extremely limited, I would say. So in that sense, what we do see is quite similar. For many years throughout the conflict in Syria, we also, like we're hearing today, we heard of calls for a specialized tribunal. That didn't play out with Syria. And I think, again, in the case of Ukraine, we're going to have a number of obstacles. I think perhaps there is greater political will than in the case of Syria. But I think if we look back on some of those particular obstacles, I think they're going to play out in our case as well. I think, though, that what we did see in the case of Syria, and this is exactly what is feeding into Ukraine right now, are a number of really important innovations that basically emerged, I would argue, because of all of these problems in the sort of stereotypical international criminal law space. So most significantly, I think the Syrian conflict basically showed us that the established architecture of international criminal justice, mainly through the ICC, but obviously with its link particularly to the UN Security Council, was moribund. It just wasn't working. And so a number of other actors then had to fill this void, had to fill this gap. And that's when we saw an absolute explosion of activity of evidence collection and accountability work that we did see take off very significantly in the case of Syria. I myself have documented some work by some actors here. And basically, I think then we can see Syria very much as the training ground of this new type of activity that we now see as, in some instances anyway, as highly professionalized experts in a range of fields, whether they be lawyers themselves going around and actually interviewing witnesses or forensic experts, military experts, whether they be actually in the conflict zone themselves or actually far removed, and sort of amassing the material and then trying to write it up in some way for future trial. And that is pretty significant, because we have seen trials that have been used, that have used a lot of this material. They've taken place already, particularly noteworthy, as many of you will know, in the case of Germany. So I think we've definitely got this very clear link that has been established between, let's call it, fragmented civil society evidence collection activity that has then fed into particularly domestic trials by alleged Syrian war criminals, and with some very successful convictions. And I think then really the key point I want to make here is that Syria became this key site of learning, this key site of professionalization for this new emerging field of radically fragmented and often privatized evidence gathering and atrocity work. And I mean, we're at the point now where I think some of this activity is far more centralized, coordinated, less fragmented, as I've already noted, maybe more professionalized than it was earlier on in the Syrian conflict. For example, only in 2020, we get the Berkeley Protocol on Digital Open Source Investigations, trying to sort of ensure that all of this flurry of activity can somehow follow some sort of standardized procedure. And this is then really vital for the way that now the actors coming into Ukraine in 2022 can actually look to these frameworks, look to this experience. They can have some sort of common vocabulary and expertise that they can then bring to the field. Okay, so then I suppose just my final points would be, what do we see then thus far in relation to Ukraine and to international criminal justice, and how does this compare to Syria? I mean, what's shocking to me or striking is the level of reference and perhaps deference to international criminal law as a key narrative frame for how we think about and how we respond to the conflict. Obviously, today, international criminal justice is a sort of required idiom for how we think about international relations, but I think it's been particularly pronounced in this case, and obviously the last few days really underscore that. But more so than just rhetoric, we're seeing, as we've all sort of noted, very, very widespread activity on the ground already. I mean, the ICC's already sent people over there. Ukraine is systematically, through its domestic authorities, carrying out investigations. But I think more significantly as well is the already extensive work and activity that we're seeing on the part of private actors who are collecting evidence. And even if you're not in Ukraine, you yourselves, anyone here could be uploading right now material onto the dedicated archives that are already being created by both private actors as well as public actors to try to gain some sort of evidentiary arsenal for potential trials in the future. The ICC has set up a portal, for example, where people can upload material. The Syrian archive that was set up in 2014 is about to set up its own Ukraine archive. I think most notably has been the work of Bellingcat. It's the sort of key open source civil society actor that's very much sort of tried to stake its claim in this field, and a number of other human rights NGOs as well are already carrying out their own investigations. So this is a field, I would say, already, highly competitive, actually, in terms of various actors trying to stake a claim and trying to show perhaps, what particular contribution they can make to responding, because it doesn't seem like there's any debate that there should be some type of response through an international criminal law idiom. But I think obviously there are some dangers here in terms of all of the promises potentially that come with this type of work. As I've said, I think that potentially much of this work will not necessarily lead to anything significant because of all of the really, really pressing sort of jurisdictional and even resource challenges that we see. As Ian mentioned earlier, I do think as well, we have to question whether the political will be sustained. So I think it's a space to watch, but I think that very much because it's so fragmented and diversified at present, I think perhaps the real key challenge here is going to be to see how all of this activity can be harnessed in a productive way, in light of, obviously, as we've already noted, the incredibly challenging political and institutional barriers that that have plagued international criminal law from the very beginning. So really then I think Ukraine presents, I do think, quite a significant challenge for the field, and we'll have to wait and see if this is going to be yet a further instance of its legitimacy and credibility being further undermined. Thanks.
Thank you, Michel. Quite a lot to unpack. Moving from international criminal law to international economic law, I'd like to invite Professor Andrew Lang to talk to us about issues raised by economic sanctions on Russia and Belarus.
Thanks so much, Michael. So as Michael says, I've been asked to say something about economic sanctions and their relation to international economic law. So I will do three things. First, I'll say something about the legality of some of these measures under international trade law. Something about Russia's participation in the WTO generally, which has been a topic of discussion. And then if I have time in my 7 or 8 minutes, I'll say something more general about what this episode might mean for the future of the multilateral order more generally on the economic side. So first of all, in relation to the question of legality, there's obviously a huge range of different kinds of sanctions. Some of them directly raise legal issues under WTO law, investment law, and so on. Some indirectly raise them and some don't at all. So there are ones that obviously relate to trade. Think, for example, of the additional duties which the UK has placed on certain goods originating in Russia and Belarus, an additional duty of 35%, cereals, oilseeds, iron and steel products, and so on. Think of export bans on luxury products to Russia. Think of bans on Russian oil and gas. There are other kinds of sanctions, expulsion of diplomats and so on, which really don't raise any issues of great significance under WTO and investment law. And there are others which indirectly do. So think of the sanctions on the Russian banks, on the Russian central bank, on major state-owned enterprise. Think of the ban on new investments in Russia. Think even of the ban on flights in UK, EU, US, Canadian airspace. All of these can raise issues around discriminatory treatment of Russian goods and services and so on. So how might they be treated under particularly WTO law, although what I have to say here is of more general relevance as well. So clearly Russia is a member of the WTO, has been since 2012. Belarus is not. Russia has a series of investment treaties, including with the UK, one with the US, but it's not in force. So some of those measures, as I've said, will clearly violate WTO law. Some won't, either as discriminatory against Russian goods or as limiting their access to foreign markets. Now, the question of WTO compatibility will ultimately come down to the availability of the national security exception. There are a number of national security exceptions in the key pillars of the WTO agreements: GATT Article 21, GATS Article 14 bis, and TRIPS Article 37. They're in more or less the same terms. And within those provisions, there are a range of different national security exceptions, but the most important one is simply the one that states that WTO members won't be prevented from taking any action which it considers necessary for the protection of its essential security interests, taken in time of war or other emergency in international relations. There's one other, or maybe even two other national security exceptions which may be relevant, but that's the most important one. And I think the only thing I really want to, let me say a few things about that. One is, clearly at a general level, this national security exception expresses the principle that where there is a genuine conflict between trade obligations and national security, clearly the trade obligations will give way. These national security exceptions are worded in a very general way, though not quite giving carte blanche to all WTO members to essentially do what they like. They've been interpreted in two cases, one between Russia and Ukraine, one Saudi Arabia and Qatar. The key issue is the question whether the essential security interests of different sanctioning countries are in fact at issue. What are essential security interests? They are something narrower than security interests more generally. We know that they typically refer to the quintessential functions of the state, the protection of its territory and its population from external threats, maintenance of law and public order internally. So for a country like the UK, are its essential security interests at issue? Well, I think it's not an absolute slam dunk, but there are a range of very persuasive arguments that you would expect the UK and other countries to be able to make. We know from the very little but real jurisprudence that we have that to a significant extent, states will be able to define for themselves their essential security interests, provided they are not doing so merely to circumvent their obligations under WTO law, which is clearly not the case here. I think specifically in relation to the UK, there are some important factors here which seem to me to go to the essential security interests, at least arguably, of the United Kingdom. So, of course, there is a potential threat to NATO territory. There have, in fact, been direct threats to retaliate against countries which assist in military terms, Ukraine. There is and has been raised the possibility of indirect but real territorial spillover of effects if chemical or nuclear weapons are used. Perhaps pushing the boundaries just a little more. There are, of course, the impact on the essential security interests of states, of refugee populations, more general threats to regional stability and so on. But I think the broader point is this is very clearly not a bad faith attempt to circumvent GATT obligations, and that clearly is relevant to any analysis. It's not, maybe that's all I will say around the legality question, but happy to answer further questions in the Q&A session. More generally, on the second point around Russia's participation in the WTO, I mean, I think we can say this, that already we know that this has become a real source of tension and distraction in the existing work of the WTO. There are a lot of delegations who quite reasonably are simply refusing to engage with the Russian delegation in the usual work and working groups and in negotiations. So this is another disruption to the work of the WTO in the build-up to the postponed MC12 in June. There has been talk of other more, I guess, stronger moves to either expel Russia as a member of the WTO, perhaps to suspend the procedural rights, the voting rights and so on of Russia in the WTO. I can discuss that, but I think the bottom line here is that this is legally extremely difficult, practically impossible, and probably unnecessary, given the fact that Russia can, and to a large extent has already been, excluded from most of the benefits of WTO membership without the formal process of expulsion, which of course is not in fact provided for under the WTO agreements. I should say, still on this point, in relation to dispute settlement, to the extent that Russia brings cases before the panel process in the WTO, the dispute settlement system has no discretion to decline jurisdiction, though of course one would expect, I think, to see a high proportion of any cases brought in that way appealed into the void. And again, if that's, I can talk more about that. Finally, and I'm looking to Michael to see if I still have a little bit of time. Okay, so finally, just a larger question. Obviously, perhaps the largest question which is raised here is what does this really transformational moment in the geopolitical order say for the future of the multilateral system and in its economic aspect? And again, I would say just a few points, and I'm happy to unpack them later. I think it must intensify the existing trend towards strategic and selective autonomy, reducing mutual dependencies in terms of supply chains and so on. So, certainly at the firm level, we've already seen that. We know in boards, there's really an urgency now to make decisions as if this sort of crisis will occur again, possibly more than once over the coming 5 to 10 years. At a policy level, the intensification of the trend towards strategic autonomy, how far that goes, I think, depends very much on how this plays out. If in the end we come to a situation in which these sanctions fail to produce real costs or fail to produce a credible perception of a future deterrent, then I think the view which has been emerging or re-emerging over the last 5 years, which is that mutual economic dependence is a net negative for Western nations' national security, then I think that's likely to become entrenched orthodoxy for at least a generation. You will see an intensification of economic delinking with geopolitical rivals, coupled of course with probably more intense integration with geopolitical allies. Certainly multilateralism will be, that will be a big blow to multilateralism as a way of doing trade governance. Final point, if on the other hand, if we emerge from this with the opposite, with a genuinely hurt and isolated Russia and a sense, whatever this means, that sanctions worked, then I would have thought that on the Western side, economic engagement with geopolitical rivals might still continue to play as a role in strategic security thinking, coupled with a much more muscular economic liberalism, I would have thought, though still in a wary and qualified way. So on that side, a commitment to multilateralism might still survive, but I think there would be a new wariness about vulnerabilities produced by integration outside the West. And so I think there's no necessarily happy, there's no good end to this story in many ways, but it's clearly an important inflection point. Michael.
Thank you, Andrew. Fascinating. Last but not least, we have Dr. Deval Desai, who is going to present us his thoughts on welfare funds to combat food and commodity price shocks, design and implementation challenges.
Thanks, Michael, and thank you for the opportunity to present some thoughts with a title that sounds boringly technical, but which I'm going to suggest it might actually indicate a big shift in development approaches. So as the title suggests, I'm going to focus on the broader implications of the conflicts for developing countries. Now, there are really important geopolitical considerations there, both for developing countries and the deepening interactions between aid and the geopolitics of the war. And that's not what I'm going to talk about. I'm going to take a policy-focused perspective on this, on development issues and this specific issue around commodity and food price shocks in particular. So I'm going to make 4 points. The first one is the scale of the crisis in a development context. And so food is the most immediate object of concern. Russia and Ukraine produce 12% of all calories consumed globally. They produce 30% of global wheat exports, and there's significant wheat dependency in particular amongst low-income countries. So 45 of the world's least developed countries import at least a third of their wheat from Ukraine or Russia. 18 of those countries import more than 50%. Eritrea imports 100% of its wheat from Ukraine and Russia. Somalia more than 90%. The Food and Agriculture Organizations estimating that conflict supply shocks could push basic food prices up by about 8 to 22%, depending on the scenario. Bread in some parts of Kenya has, since the start of the conflict, the price of bread has jumped by about 40%. So there is a general concern and a deepening one about food insecurity and food poverty. This is likely to be coupled with commodity shocks, oil and gas shocks in particular, that we are familiar with in sort of just even the broad news reporting. The fundamental point is that adding all of this together, there's major current vulnerabilities in low-income countries to food poverty, to poverty more generally, and with the possible political and social instability that might go with that. And this is, lest we forget, layered on top of major existing epochal sort of crises around food and its relationship to poverty. So COVID and the environment have both already taken and are continuing to take their toll. In 2021, the UN requested a record amount of development aid, 41 billion in that year, and already it has requested 3 billion more to manage the effects of the Ukraine conflict directly itself, never mind the spillovers to occur. So that's the first point, the scale of the crisis. The second point is the response. So it looks like governments and donor communities are drawing on the idea of the trust fund as a policy framework to respond. And that is both nationally and globally. So there are a series of proposals for ring-fenced funds to target the effects of the food and commodities crisis on the poorest and most vulnerable. The FAO has been arguing, the Food and Agriculture Organization has been arguing in favor of these targeted funds. At the national level, the UN Special Rapporteur on Extreme Poverty has argued that there should be a central plank of government policies towards food insecurity in particular. India has ring-fenced $22 billion to bring down fertilizer and other agricultural input prices through special purpose taxation. Also at the international level, the IMF Resilience and Sustainability Trust Fund has explicitly been oriented towards tackling the spillovers on food prices from the Ukraine crisis. So trust funds had been out of fashion in the last couple of decades in favor of moving towards support to and spending through ordinary budget lines, particularly ordinary state budget lines and general purpose funds, budget support, for example. But now it seems trust funds are very much back on the agenda as a policy response. And it seems logical, right? So this is a targeted response to a really specific set of concerns, food shocks, commodity price shocks. And this is especially true if we take into account the backdrop of plausibly development aid reducing in favor of military spending amongst donor countries and bodies. So generally less willingness to provide general and discretionary funds and more of a desire to target what aid money is left towards specific shocks. But this is trust funding on a massive scale. And this raises a couple of really significant issues that I want to raise based on research that I'm doing at the moment on national level welfare trust funds, but also I'm starting to look at international trust funds and multi-donor trust fund experiences in particular. So that was the second point, trust funds are back. And the third point is to raise a couple of key issues. So a general challenge with trust funds that's well established is that disbursement rates tend to be low. It's pretty hard to get money out of the door, whether that's at the national level. In India, for example, 75% of large ring-fenced funds, trust funds for various vulnerable social groups are underspent. At the international level, rates vary, but it's been a long-standing policy issue that development banks have noted. It's really hard for them to spend trust fund money compared to direct loans and budget support. So we know that trust funds have low disbursement rates. My research has been suggesting that the key issue here isn't just fiscal capacity, which is usually what's been where the problem has been identified. You know, do states, do development banks have the fiscal capacity to get trust fund money out of the door? It's also the institutional setup of the funds. So this is where the legal perspective comes in. The institutional setup of the funds really matters. And so I'm just going to make 2 points here. First is that the institutions matter, but in particular, the accountability structures matter. So we know, and trust funds have traditionally been oriented towards strong scrutiny of spending because they're designed to be really worried about misuse of funds, poor programming, corruption in particular, as the experiences with the Afghanistan Trust Fund raised. But strong scrutiny of spending can really gum up spending. Conditions might be too onerous, review and audit conditions. Functionaries might be really afraid to get the money out of the door. And there is a lot of research that suggests that this is a major issue that leads to underspending and often to non-spending altogether. We're seeing some research coming in about COVID relief funds that have been put in trust funds and billions have been left unspent from Canada to India. So we know that accountability structures matter, and this is often exacerbated by a lack of clarity on who's responsible for actually getting money out of the door, which tends to be harder to see as the problem being tackled gets more complex. So this squarely is the design and implementation problem that I think we need to think about now before we get too gung-ho about tens of billions of dollars of trust fund money to tackle food and commodity price shocks. The second crucial point that we haven't paid as much attention to is that the institutional setup that governs trust fund spending transfers itself into state structures, especially when a large amount of state expenditure comes from trust funds, as is going to happen here. So states organize their administration, their accounting, their audit processes to fit trust funds rather than what the government needs. And this is an even more, an even stronger version of the arguments about donor-oriented state structures. Here you have a firewall between the trust fund and the ordinary activities of the government. So the state's having to build an altogether parallel structure to facilitate the spending of trust fund money. So really, this is the risk of building trust fund states. Now, this divide might weaken state capacity, but it can also weaken big state structures that we might care about. So in my research, I've seen how in some circumstances, government departments might borrow the money sitting unspent in the trust fund to fund their ordinary activities. Now, even if this borrowing is fully repaid, it's a way of funding government activity without legislative scrutiny of appropriations. So there are a lot of broader state and governance effects we might want to think about when we're thinking about the implementation of trust funds in large scale. So in some, trust funds are becoming more and more popular. Their design is not just a fiscal matter, it's also an institutional one. And as a result, it's a political issue and not a technical issue, with potential major spillover effects on state structures, especially the risk of building trust fund states.
Thank you, Deval. I think we have 15 to 20 minutes left for the Q&A. Deval, I'm happy to take.
Well, so I was just going to pick up on while people might gather their thoughts. I get the first thing to say is if you do have any questions you'd like to pose orally, please do just raise your hand and we'll take them. And while you gather those thoughts, I'll just turn to some of the questions that have been thrown into the chat. So there was a general question, but it mainly in response to Filippo's intervention, which is, will Russia object to the jurisdiction on different grounds of various courts and tribunals? For example, the ICJ, the ICC, the WTO. This seems to be a trend. So Filippo, maybe Andrew, you might have views on that. Filippo may have frozen. So Andrew, I think, oh no, he's back. There we go. Go ahead,
sorry, I keep freezing because it's very cold. And so let's not forget that Russia is deciding on a case-by-case basis whether to participate or not in these proceedings. So objections are sometimes actual objections and sometimes disguised as non-participation or some position papers that leak here and there. Yes, of course, strong objections to jurisdiction in the ICJ for sure. And I would understand why. This is a creative or contrived claim. And so Russia would essentially say, I have not breached the convention, why are we here? Sorry, I'm simplifying. When Anna-Maria, you mentioned investment cases, you might be thinking about the Crimea ones and what happens now if Ukrainian investors want to sue Russia for things that have happened in Ukraine, which is an unorthodox way to bring a foreign investment claim. I would assume the same pattern will repeat with Russia saying, this is not Russia, so I'm not bound by the bilateral investment treaty. The ICC, I'm not sure you mean the International Criminal Court, on which I'm simplifying massively. The problem is not so much jurisdiction, is whether there is any possibility to apprehend the individuals in question. And the ICC, in terms of International Chamber of Commerce, I suppose it would be the same problem we see in investment arbitration. So a range of jurisdictional disputes, some of them plausibly built, will be used for sure, either directly or indirectly in case of non-appearance. Thanks.
Andrew or any other colleagues who want to jump in here?
Yeah, I mean, I'm happy to say something, and maybe I'll fold in because I see, Emmanuel, you've also asked a question which I guess goes along similar lines. I mean, I think, I guess one point I would add just in terms of jurisdictional objections in the WTO, or more generally WTO litigation against Russia, I think there's pretty good reason to question whether other states will choose to engage with Russia through dispute settlement. I know there's, in the WTO in particular, there are a few reasons to think they won't. One is, I guess, Emmanuel, exactly as you argue, Russia will in its turn have seek to rely on the national security exception. And there is, and I'll say more about that in a moment, but there's there's sufficient strength, I guess, to that exception to think that it will be a significant issue in any claim brought against Russia, mostly. Plus, also more generally, we've seen cases, for example, one of the EU cases against Russia has already been, on something entirely unrelated, has been already suspended. And I think there's a sense in which engagement with Russia through the WTO dispute settlement system isn't really appropriate now. And then, of course, any case, I mean, there's the possibility of appeal into the void. So I think there are some pretty strong reasons to question whether, at least in the short to medium term, that will be a strategy of engagement, which to some extent puts the question to one side. I mean, on the substance, Emmanuel, I mean, just to say again, so of course there is a plausible case in the case that you mentioned in the chat box, in the circumstances you mentioned in the chat box, a plausible case for Russian reliance on Article 73 of the TRIPS agreement. I mean, so just remember the deferential approach taken to the interpretation of the words it considers necessary, and as I said, to the words essential security interests. I mean, we do know from the Saudi Arabia Qatar case that where a measure like the one you're talking about, suspension of the rights of IP holders, where that impacts on the rights of IP holders from third countries or, essentially unrelated parties, then you can get a problem. But apart from that, I would have thought that there's a sufficient degree of difficulty in the legal case against Russia in that case that you'd think twice about bringing that case. But, I think the point is a little bit to make.
Filippo, I see you want to come in, but I just want to see if any of our other colleagues have any, or was that a direct follow-up?
Yes, a direct follow-up on this particular case, sorry. And this is to Emmanuel's question. Of course, Andrew is right, 100% on whether the security defense would be available. But if we take a step back, what are the chances of anybody suing Russia when the most that you can get out of litigation is the right to retaliate and suspend concessions, which these unfriendly states are doing already unilaterally? So it seems to me that it wouldn't be very likely that such litigation would exist. We are at the point where the parties just, are hostile to each other, and that's it.
Are there any other reflections on the jurisdiction question? So there's another question which William Quinn, I think, posed, which it sort of has two parts. The first part of it is descriptive. Does the international legal response to Ukraine demonstrate essentially a two-track response to or concern with particular crises? Might be some version of a Eurocentric argument. Does it respond differently to crises in European states and elsewhere? And the second question is a little bit more of projecting into the future. Might this crisis change the ways in which international law operates as a crisis discipline? Is it the ways in which it thinks about crises in general? So sort of conceptual questions, but did anyone have a response in that regard? It cut across a few of the presentations, including, I think, Steve's, Michel's, Casey's.
I can say something very quickly. I mean, I think it links actually with yours as well, Deval, because I think the key thing is, what do people in the global south want? Do they want criminal trials? Do they want Russia expelled from the UN Human Rights Council, or do they not care? Do they actually want better bread costs? And what are going to be the spillover effects of this? Because often, in terms of, say, human rights, it's actually economic, social, cultural rights or development concerns, and we see this all the time with the International Criminal Court. People want reparations. They don't really care so much about the trial. So I think it's going to be a little bit about actually how the ripple-on effects maybe need to be addressed more, and I think in the crisis mode they're not, and so it's definitely this high politics, high law response, which of course is needed, and that in and of itself is, I think, highly selective, and can be charged as Eurocentric, but I think as well it's more those sort of unintended consequences and the fact that they won't get as much airplay that is really quite concerning.
Could I say just a quick thing about this as well? I rather agree with that what we see here and have seen in earlier instances is this sort of continuing shadow effect byproduct or reverberation of the historical fact that international law did arise as a European creation out of European politics over the centuries. Many people deeply resent that, and for various reasons, but that is a historical fact. And I think we see reflections of that now, that when crises arise in Europe, they just seem to be regarded by the major powers, at least, as just ipso facto automatically more important. Think, for example, how much more attention was given to the Yugoslavian civil wars in the 1990s than to similar crises such as the Lebanon civil war, even the Syrian one, the Libyan one today, or Ethiopia. All of these receive a very great deal less attention. And the United Nations itself arose out of the concerns of the Grand European Civil War, as we might call it, known as World War II. And so the whole system is still strongly Eurocentric or developed country centric. And I think that there is not any reason to deny that. Now, there are many reasons to struggle against that and to do what we can to ensure that international law is important and effective in other parts of the world too. But this is a demonstration in part of how far we have yet to go along that line.
Perhaps I can just add, before we go on to Adrian's question. So shortly after the UN General Assembly vote on the resolution condemning Russian actions, Bangladesh abstained, and Lithuania, in direct response and explicitly in direct response, cancelled a shipment of 449,000 COVID vaccines to Bangladesh. I reflect on that simply as the transformation of a crisis, and that shipment of vaccines was part of actually quite a long international legal and policy process, building an architecture for the sharing of vaccines and its distribution in response to a geomobile but global crisis. And just like that, through a sort of pretty brief geostrategic calculation, that delivery was cancelled. It's still not quite sure what to make of that. I don't want to read too much into it, but I thought it was just an interesting layering of one crisis over another. We have a question about personal characteristics. To what extent are provisions and liabilities differentiated to accommodate the diversity of personal characteristics? Casey, do you have any reflections on that?
Yeah, it's a good question. And I think one that I was trying to get at by discussing the various treaties that are applicable in both Russia and the Ukraine. And I think the reason why I mentioned both the Disabilities Convention, the Children's Convention, and the Women's Convention is that that documenting of different violations is being done, how carefully and to what degree of sustainability. For purposes of international criminal law, I don't know how much play that would have, but it definitely broadens the particular and intersectional characteristics of different victims of, say, indiscriminate bombing, or more horrifically and not necessary to the conduct of war is the allegations of rape against women, children, and disabled people that have come already. Haven't been verified, but these are parts of armed conflict that we've seen in other settings. So I think taking note and the documenting and maintaining of evidence for these types of things will come into play eventually. In the international criminal context, possibly as aggravated characteristics of a particular assault, but in terms of human rights, it definitely broadens the scope of applicable mechanisms that have the potential to oversee a claim brought on the basis of this. And I should also note that this goes in the context of both Russia and the Ukraine, because as other people have pointed out, that we have to be alive to the fact that the potential for human rights violations and international criminal law violations and laws of war violations are just as potentially, could also potentially see Ukrainian perpetrators as well as Russian.
We are imminently out of time. We have one more question on the table, which is essentially, is law timely enough for ongoing crises? Big question. And Michael, given that you're working across a couple of different crises, I wonder if you want to take that and also have the last word.
Quite a tricky one. Legal responses are usually ex post facto, so we are very often just passive observers of power politics, I'm afraid. I was just recently looking at the use of thermobaric weapons by Russia in the conflict, which are volumetric weapons designed to kill by primary blast effect and secondary thermal effect. And when you look at the law, well, it seems that Protocol 3 of the 1980 Conventional Weapons Convention allows for thermobaric weapons to be used if they're not specifically targeted on civilians. So I would say the law has gives a lot of discretionary power to belligerents during wartime. Let me finish by inviting the audience to follow the Edinburgh Centre for International Law and Global Law calendar. We have a Law of the Sea event, which is taking place in person on the 27th of April. And we also have a virtual event on the 3rd of May about international humanitarian law applicable to the war on drugs in Mexico. So to the audience, we hope to see you soon in person and virtually to continue our conversation about the role of international law. So I want to thank you everyone for your participation, and I want to thank all the presenters for stimulating conversation and debate around the Ukraine crisis. Thank you all.